The Good Legal Stories series features landmark environmental cases from around the globe through the voices of those who worked on or decided the cases. We're here today with Neil Kagan, who joins us from Oregon. Jimmy?
So let me tell you a thing or two about Neil, and his full bio is online along with this recording. But the end of the story is that Neil was instrumental in the United States in bringing a lawsuit that eventually led to protection of 8 million acres of land for wilderness purposes, one of the most impactful cases in American history. In that regard, let me tell you a little bit about Neil. He graduated with a degree initially in biology from Penn State University, and then from Michigan State University has a master's in entomology. It's kind of an unusual thing in environmental law, and something that turned out to be very beneficial, which you'll hear more about. His law degree is from the University of Oregon, where he joins us in Eugene. His story begins in a very fascinating way, again, very early in his career, right after law school, when we're all trying to figure out what to do. Something very consequential happened with Neil. Neil, tell us the story of this case. Go ahead.
Okay, thank you. The story about the case begins with wild forests. The case particularly was about wild forests in Oregon, but its impact was felt in wild forests around the United States. Back in 1983, I was living in Roseburg, Oregon, with my late wife, Betty Reed, and east of Roseburg lies the Umpqua National Forest. And in that forest, there's an area called the Boulder Creek Watershed. And Betty and I would go hiking there. We'd hike uphill to a wide, flat expanse of land high above the creek, which was covered with ponderosa pine trees, ancient ponderosa pine trees. These trees shot straight up 100 feet or more into the air. And the trees were so enormous that when Betty and I stood on opposite sides of the tree and reached our hands around the trunk, we couldn't touch each other's fingers. That's how big they were. There were many more wild areas in national forests in Oregon and around the United States. These areas had never been cut for timber or invaded by roads. They were untouched by Western civilization. In the 1970s, the US Forest Service began studying these roadless areas to determine whether they should be added to the National Wilderness Preservation System. That system had been established through the Wilderness Act, which was passed in 1964. In 1979, after completing a study known as RARE 2, the Forest Service recommended only a fraction of millions of acres as wilderness. The Forest Service released most of the roadless areas for development, and these decisions were very controversial. In 1983, a small environmental NGO decided to sue the Forest Service because the roadless areas that had been released in Oregon were being actively destroyed by logging and road building and other activities. The NGO is known as the Oregon Natural Resources Council. Now it's called Oregon Wild. Anyway, the council hoped that a court order stopping development would pressure Congress into setting aside more roadless areas as wilderness. So the lawsuit was filed, and a month later, the Forest Service decided to stop selling timber in millions of acres in Oregon's national forests. And this stopped logging and other activity, destructive activity, in all the roadless areas that have been studied in Oregon, about 2.25 million acres, while the lawsuit was pending. Congress was concerned that this would encourage copycat lawsuits around the country and a freeze on logging and other activity in millions more acres around the United States. And as a result, Congress was determined to find a compromise to settle the controversy that surrounded the allocation of roadless areas, whether to wilderness or to development.
That's fantastic. That's a great introduction. Thank you so much for that. I'm wondering if you can tell us a little bit about what Jimmy mentioned in his introduction, a little bit more about the lasting impact of the work that you did.
Sure. Well, the Oregon lawsuit was important because of the value of wild forests. Wild forests provide habitat for wildlife. They preserve biodiversity. They maintain high water quality in rivers by preventing erosion and siltation. They capture carbon, mitigating the effect of climate change. And they also provide an opportunity for solitude and the appreciation of nature. The case matters because it prompted Congress to designate as wilderness more than 7 million acres of national forests in 23 states, and including Oregon. And that's almost double the amount the Forest Service had recommended as wilderness in those states. And the legislative history of Congress's deliberations leading up to the enactment of these laws shows very clearly that it was the Oregon lawsuit that was responsible for spurring Congress to enact the laws. That's why the case is important.
It's so interesting because we often think about lawsuits being brought under law. So you have the law first and then the litigation. And here you have the litigation that spawned the legislation. So I think that's a really interesting dynamic. Thank you for that.
Sure. Yeah,
and
just
to,
you know, the basis for the lawsuit was the National Environmental Policy Act. The problem with the Forest Service's evaluation of the roadless areas was that it didn't adequately describe the areas that were to be impacted by development, and also didn't include the public in a meaningful way so that the public could be informed about the agency's decisions.
So Neil, if we could just spend a minute or two, I mean, this isn't, supposed to be a deep exegesis on United States environmental law and policy, but it's complex, right? You've mentioned NEPA, you've mentioned national forests, you've mentioned wilderness areas, but you have a mix in these cases of different federal agencies and different designations for federal land that ends up being very impactful. I wonder if you could just take a minute or two to outline or kind of a taxonomy of how that fits together for people who may not have any idea.
Okay, well, much of the land let me put it this way. The United States owns a lot of land in the country. That is, this is land that the United States acquired when it became a country, and it's held on to a lot of these lands. They're public lands. And in the 1970s, and even a little bit earlier, there was a movement in the United States to protect these public lands, which are administered by the U.S. Forest Service and also by the Bureau of Land Management and other agencies within the federal government. And so to guide the agencies in their management of these lands, Congress enacted various laws, and in particular enacted the National Environmental Policy Act to ensure that when the government made decisions about how to manage the lands, that they understood what the impact of their decisions would be, keeping in mind the environmental impact in particular. So what was happening was that then the Wilderness Act was enacted, actually before the National Environmental Policy Act. And so when agencies began making decisions about areas that met the definition in the Wilderness Act of wilderness, they had to take into account what the impact of their activities would be vis-a-vis the wilderness qualities of the lands they were responsible for. So that's how all this came about. I hope that answers your question.
Yeah, exactly. And I think what is or can be confusing to people who aren't from the United States is just the mix of different kinds of federal land, like forest land that's administered by the Forest Service under the National Forest Management Act. It's not wilderness. It's under the auspices of the Department of Agriculture. So there's a great history and story to be told there about why those lands were set aside to grow trees, in essence, that were fast growing and could support the Navy. Your work resulted in, I'll use the word advisedly, but permanent protection of various lands as wild, and they can't be cut. They're where the famous line about it's where the hand of man has not set foot. They're supposed to be for future generations, and among the only areas that the federal government administers that are not subject potentially to development. Do I have that about right, Neil?
Yes, very much so. That is exactly the purpose of the Wilderness Act, to maintain in a primitive state certain lands that have a certain size and certain characteristic. And the purpose indeed is to set aside these lands so that they remain wild in perpetuity. So the outcome of this particular case was to set aside as wilderness forever, as 7 million acres of Forest Service lands. There were additional 1 million acres of also other federal lands under the jurisdiction of an agency other than the Forest Service that also were set aside as wilderness when Congress was in the process of protecting these forest lands.
Yeah, and ultimately protecting land as wilderness in 23 different states.
That's right.
Yeah. So, I mean, it's a fascinating story, and it resulted in, again, this elevated protection of land that matters to people now, their kids, future generations. They serve as carbon sinks, as you mentioned, places for for primitive biodiversity, if you will, and for just the experience as a human being of being out in places that haven't been disturbed by other human beings. So thank you. Could we hear more about your story, your involvement in the case, and how it came to you?
Sure. So what happened was I graduated from law school in 1981, and I was admitted to the bar in 1982. So I'd been practicing as a lawyer for about a year when the Oregon Natural Resources Council decided to want to bring this lawsuit. And the council didn't have the money to pay a lawyer, so it needed to find a lawyer who would take an environmental case pro bono or for free. And there were very, very few lawyers anywhere in the country in private practice who would take a case under those terms. But that is exactly why I went to law school, to become an environmental lawyer. I have the background, as you said at the beginning, in biology and studying ecology. And I was a child of the 70s and grew up greatly influenced by the environmental movement. So I went to college with the intention of eventually going to law school and becoming an environmental lawyer so I could defend the earth. So the council approached me in 1983 to take this case. As I said, I had been a lawyer for just a year. I had my own solo law practice. I was working by myself. I didn't have many clients. I was making very little money. I probably was below the poverty line, but I was lucky because I was married to another lawyer, Betty Reed, who had a good job with the county, and we basically lived from paycheck to paycheck, her paycheck. So it was definitely going to be a bit of a sacrifice for me to take this case, but Betty had faith and believed in me and also cared a great deal about the environment. So she readily agreed to me taking the case pro bono. She was well aware that this meant that I'd be passing up the opportunity to work for clients who would pay me. So she deserves a great deal of credit.
Thank you. A great story. Other than having a wonderful and supportive spouse, I'm wondering what advice you have for the next generation of lawyers, for lawyers today coming out of law school or starting their careers, but really wanting, like you did, to have an important and lasting impact on environmental and human rights. What advice do you have?
Good question. I suppose one bit of advice is to evaluate a case objectively and save your passion for prosecuting the case. Know your case intimately and know the opposing party's case as well as or better than it does. And once you've decided that your case has merit, to ignore doubters. Just proceed aggressively and assertively to advocate for your side. And then I guess finally, win or lose, be proud of yourself for trying.
That is really fantastic advice. Sort of a combination of being scrupulous in your initial analysis and in your analysis the whole way through, but also being driven by a passion for what you're doing and a conviction that what you're doing needs to be done.
Mm-hmm.
I think people need. Thank you. Thanks so much for that.
You're welcome.
Yeah.
It also strikes me as serving as a reminder. I don't remember, it was Margaret Mead who's quoted as saying something like, never doubt the impact that an individual can have on the course of the earth or something like that, because after all, those are the only people who ever have. Okay, I totally blew that. But anyway, it's a wonderful quote and it makes me think of your story. Neil, the last question I have, I'm just curious, did you have any idea that across the Pacific Ocean in the archipelago of the Philippines, that you had a kindred spirit who was also trying to save forests in the Philippines, Tony Aposa? It was about the same period of time. I'm just wondering if you had any idea that he was doing sort of many of the same things and trying to, save areas from timber leasing agreements for future generations to protect wilderness and so on and so forth. Any idea?
I had no idea at all. And it's great that now we do have these connections. Because we can learn from each other and help each other. But no, at the time, I was operating completely by myself. So, no.
Well, what's the expression as well, and that we're all in this together and inspiring each other, standing on each other's shoulders. Thank you so much for your great work in protecting millions of acres of land for perpetuity, and all beginning with having this wonderful scenario where you had no idea where it was headed, and in devoting yourself to it. Erin, do you have any final comments or anything?
Just thank you so much, Neil, for that work and for taking that on. And thanks, of course, to your wife also, who I'm sure had a lot to say about it while you were working on it. And it's just so, it really is inspiring just how the kind of impact we can have, and we don't even know it, but it can last for many years, as your story shows. So thank you so much for taking the time to talk to us about this today.
Well, thank you. I'm happy to have done it and appreciate being asked.
Okay, so let's thank Neil Kagan again. That concludes this session of the Good Legal Stories movement. That was another fantastic legal story. Thank you so much for joining us. Bye-bye.